How do I keep my estate away from my son-in-law or my daughter-in-law? Hi, I'm attorney Steve Reilly, and today I want to discuss with you first the reasons why people want to keep their estates away from their son-in-law or their daughter-in-law, and secondly, to discuss some of the things that we might be able to do together in our estate planning plans as to how to accomplish that very thing. Well, first, people sometimes come into my office and they talk about their son-in-law as if he's the son of Satan, or they talk about their daughter-in-law as if she's the daughter of Mephistopheles, and so on. I hear all the horror stories. You know, people are concerned about what happens if their son should die after they give them their inheritance, or their daughter should die after they give them their inheritance, and then everything ends up going off into another bloodline. That's a big concern of people, and today we're going to talk about that more. Well, what can people do about it? Well, firstly, you can have a discussion about, well, what are you trying to avoid, right? So in other words, if some people simply tell me, look, you know, I'll just simply give it to my son or my daughter. What happens after that, you know, who the heck cares? My son or I'll be dead. So what happens, happens. Some people tell me that and say, you know what? Let it go to them and let them deal with it. I'm not going to get involved in anything that would be complicated or anything that would be expensive or something like that. So they feel, let's just give it to them and then let the chips fall where they may. You know, they look at it that way. I mean, I guess that's one way to deal with it. But obviously, that's fraught with potential of having the very thing happen that you were afraid of in the first place. The second thing is that you can have created various types of trusts. You can create a trust that limits what stuff could be spent on. If, God forbid, something happens to your child, then the rest of that trust corpus, or as they call it, or the trust principle as they call it, you know, is what's left in the trust can go in another direction, away from the individual you didn't want to have his or her hands on it, right? So you can have a trust that makes it go back in another direction after your trustee spends on the various things that you allow him or her to spend on for that trust and so on. So you can keep some control about that and keep ways that way you can make sure that, you know, that something just doesn't simply go off in the wrong bloodline. So one way is to simply have a trust for your child themselves or your children. The other thing you can do is you can bypass your children altogether, a child or children altogether. You know, you can simply set up a trust that has things go directly to grandchildren. So that then you could also appoint someone else to be the trustee of that trust, or even your son or your daughter, and then have a substitute trustee. Once they die, it goes off to another person to be the trustee, not the person or the son-in-law or daughter-in-law. You can create trusts that, for the benefit of the person, your son or your daughter. You can create trusts that are for the benefit of your grandchildren, bypassing your children altogether. Or you can even have a trust that takes into account, you know, your child or your child as well as your grandchildren being among the group of people that your trustee can do various things for. And then you create it so that the assets will eventually stay in your bloodline. However, whatever assets are doled out within that particular trust, once they get in the hands of the spouse, are now able to be, grabbed, so to speak, by the spouse. The other thing you'd have to be very careful of if you live in a community property state, to make sure that you talk to your attorney in that state to determine the ramifications of community property laws upon things that your child would get. I practice in Connecticut, so I don't practice with any community property laws in existence, but those are things, if you're outside of Connecticut, you want to make sure you discuss with an attorney that's in your particular state. If you are in a community property state, like I think Louisiana, I believe, is one, and California might be another, and there's several others, I guess. But other than that, you want to make sure that community property laws aren't affecting or how they affect what you're trying to accomplish. You know, you can, in a trust, you can determine what things are spent on. You can even have withdrawal rights on the part of a beneficiary, or what distributions could be made during that time frame to a particular beneficiary in certain given amounts, or certain, you know, with under the discretion of the trustee. So you can do it by way of creating some kind of trust. They're complicated, but to an extent. But the reason for that is life's complicated. You know, so sometimes we got to make these things, but proper trust can do, and proper estate planning can accomplish what you want in this realm. Well, I hope you enjoyed this video, and if you did, I would please ask if you give it a thumbs up, or consider subscribing to my channel, or ring the bell over there, and this way, whenever any new videos come out, you'll be notified. Well, thank you for watching, and have a great day.